Front page?
Oh, yeah, you were on the front page.
Oh, yeah.
Voted name and all.
I guess I should look at the paper more.
There's more juicy stuff, maybe.
Knew it was coming, something. Then 2 weeks.
They're coming out later and later than they previously were, I felt like.
But it was kind of funny, yeah. It's denied, but you can try again. It says.
Yeah, that one. Gets looked up later. No, thank you. Yeah. I don't know. Right.
Yeah.
That was
We then call the meeting in order. 6:35. Roll call shows all members of the commission here. There's minutes from the February 7th meeting. Did everyone have a chance to review them, and are there any questions?
No questions, reviewed, and I'll make a motion to approve them.
Second.
All right, we have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? Motion passes. Unscheduled citizen participation. Is there anyone in the audience here to talk about something not on the agenda? Just the button. There you go.
Oh, Donna Reddy, 1133 Grand Avenue. I love the lights in the town square. And I know that there's some kind of deal where maybe the guy's supposed to take them down and put them back up, but it's beautiful having them on February, March, April, August, September. So anyway, I'm just hoping that you'll leave them on all the time. Tell the guy we don't need you this year to take them down. And another thing, at the end of, just past the office where everybody does the U-turn, I know there's a little bit of signage about parking and so on, but if we could just simply have the town guys type a big, like 3-foot letters that say lake with an arrow to the right and parking with an arrow to the left, then it'll be real obvious right in front of them where to park and where to go to the water. Because you wouldn't believe how many times we talk with people on the boardwalk in the summertime, and they have no idea there's a lake on the other side of Charlie's. It's just amazing. So anyway, lake and park, just paint it. We'll provide the paint. So that's all. Thank you.
Thank you. Anyone else? All right, if not, does anyone have a conflict of interest with the one item of business tonight?
No conflicts.
All right.
No conflict.
Hearing none, we'll move on to the first item and only item of business, a public hearing continued from January 17th, consideration to adopt resolution 1/2024. A resolution considering a variance to municipal code 12-229 regulating stream and lake setbacks located at Sunnyside addition to Grand Lake, lot 18, block 1 and A, track east of lot 18 to the center of the north inlet, also known as 210 Rapids Lane. And we'll go ahead and open the public hearing.
Wake up.
Wow.
Mike does the purpose of this hearing is that the town received a shoreline variance request for a newly constructed deck partially in the 5-foot non-disturbance zone within 30-foot shoreline setback, and no permit was obtained prior to
Sorry,
construction.
can you?
speak up?
Yeah.
We can't hear you.
Sure.
Can you turn your microphone up? Is that like doable?
That one shows it off.
I just turned it off so it wouldn't do that thing, so I could move it.
Oh, okay.
I'll do that thing.
The town received a shoreline variance request for a newly constructed deck partially in the 5-foot non-disturbance zone and fully in the 30-foot shoreline setback area. No permit was obtained prior to construction of deck. And you can see what we're talking about on the screen or on your sheets. The 5-foot setback is labeled in green. The areas that are yellow are in the non-disturbance area. And the blue line is the 30-foot setback in which the town requires a shoreline variance request to be obtained before any kind of activity is done in that area. So the applicant, well, what happened was basically the staff obtained an image from social media with the new deck showing. So they investigated and sent a letter to the applicant and requested that they apply for a shoreline variance and a building permit. And they responded with what is in the memo. The owner of the property had Never Summer attorneys correspond directly with the town on the matter. So we have Mr. Krob here to discuss the matter as well. They stated to the town that the deck predated the shoreline setback regulation, and it was a floating deck. It's not dug into the ground. It's not attached to the ground in any way. And so since they did not disturb the ground, they did not feel that they needed to apply for a permit. We contacted the building county official and asked if that was the case, just to confirm before we went down the wrong path, because we don't want to start anything. So we asked and they said, yes, they do need that. It is international building code. It's a commercial property open to the public and they're supposed to have a permit. So we let them know that, and they, we also spoke with the state flood insurance group, and they said that we require floodplain documentation for anything that's in the floodplain. And that is so that the town's federal flood insurance doesn't get revoked if something happens and FEMA comes and audits us. So they just have to file that, and they did. They submitted a floodplain application. We reviewed it and went over it with the state, and they said that because of this location, they only need the encroachment analysis done to ensure that if waters do rise, it doesn't cause a pinch point. And staff doesn't believe that it would, but if state needs that on file, we've asked the clients to provide that, and they said that I believe they said they would in an email if they needed to do that. So according to our municipal code, which is the main reason we are here, is that in order to preserve the environmental quality of the water in Grand Lake, a 30-foot stream and lake setback is shall be maintained for all improvements to a site. And when activities are proposed in the 30-foot setback, a variance may be requested by the applicant. And that's why we're here. The 5-foot setback is a non-disturbance zone, and there is no variance application process for that 5-foot disturbance zone. And it's only allowed for access to shoreline like marinas or boathouses or things like that, where it's a 4-foot or less walkway going to a structure. So when we reviewed the history of the site, we did find in their file that in 2011, they were reinforcing the shore, which is great. And we have photos from the file there. And just as a reference point, There's a tree in the middle, and they did kind of chop that down to make it into a cool little seat. And so that's what those points are, just to show you kind of where things were. And to show that perhaps this soil was compacted, and that does suffocate tree roots when things are compacted and there's frequent walking or pressure on soil. It's a known fact that things get compacted like that and can kill things. So that's all those pictures are for. After they did their shoreline reinforcement project, they, which they did with a permit and they did everything to the book. They revegetated the lawn and it looks good in 2014 and some pictures by 2019 and 2020. Most of the soil looks like it's been compacted and walked on. And so there's nothing really growing there. I don't see any tree roots or anything, but that's neither here nor there because these pictures aren't that detailed. And that's figure 6 and 7 is what we're kind of I'm scrolling through. And then sometime during 21 through 23, deck was put in place. And the clients or the applicants have said that it's to cover the uneven dirt and shoreline and possible exposed roots. And that makes sense. It looks like it probably is covering that and protecting the soil from further erosion and trampling and compaction and killing trees. So they probably won't lose any more trees, hopefully, with this. However, the main concern with the town was there was no construction document submitted. So we don't actually know a number of items that we need to know, which is how is the deck going to stay there if water does rise? Is it anchored in some way? They say it's a floating deck, so people downriver with the floodplain management application, it talks about can the thing be dislodged, or when I was speaking with the floodplain administrator with the state, they wanted to know how it's anchored so that if it does dislodge, what happens downstream to other buildings. That's the main concern with that. The deck is in figure 9, that is the FEMA flood zone A, and the arrow there is pointing, half of the gazebo is in the floodplain, and then there's a little umbrella, and then pretty much all the way south of that would be where the deck would be in figure 9. So it's squarely in their hazard zone A, which is why that's where the water would go if it were to flood. That's what that space is. The high water mark is not, it's not the same thing. The high water mark is actually where the stream is. And if they were in that would be a whole different thing, but they're not. They're and they're above it, and likely nothing will happen. It's just we have to have it on file to keep our insurance for federal flood insurance current. That is. So the applicant submitted paperwork for the shoreline variance as we requested and the floodplain application as requested. And after reviewing it, as I said, we requested the encroachment analysis that the state has requested of us. The existing deck is used by right in a commercial transitional zone, which is what this is, an accessory use, which is, it's okay. It's legal. And the only problem is we don't have construction documents. So staff published this in Middle Park Times as we were supposed to and sent out notices. We got 14 of the 23 notices back. And as you know, we continued this from January 17th due to the winter storm. So the items that the commission has to go over, you have items you have to choose if it complies with in the municipal code. And that is on page 5. I believe it's on page 5. Actually, it is not. It is in the resolution at the bottom. I apologize. I will read them in a second. 29. So on page 29 is how you can discuss. You have to hear the burden of the applicant and establish that the activity conforms with one or more of the following exceptions to section 12.3.5A.4A through E. One or more of the following exceptions. So it doesn't have to be all of them, but it can be one of them. And that's A, by reason of exceptional shape, size, topography of lot, or exceptional situation or condition of the building or land, practically difficult or unnecessary hardship would result to the owners of said property from strict enforcement of these regulations. Or B, literal interpretation of the provisions of these regulations would deprive the applicant of rights commonly enjoyed by by other properties in the same district under the terms of the regulations. C, the special conditions and circumstances do not result from the actions of the applicant. D, granting the variance will not confer on the applicant any special privilege that is denied by this ordinance to other lands, structures, or buildings in the same district. Or E, that the granting of the variance does not pose a detriment to the public good and does not substantially impair the intent and purpose of the zone and these regulations. And so the Planning Commission would discuss those items, and if one of those items you find that this project meets, then you can okay a variance for the shoreline activity that is being done in the shoreline, which is a platform or a deck or disturbance or people being there with tables. What is happening in that area? So that's what it is just the shoreline variance to do something in that space. And as I said, there's no variance procedure in our code in the 5-foot non-disturbance area. So to go back on page 11, I believe, to finish what I was going to say up there, and actually it was on page 12, sorry, it was. If the commission recommends granting a variance to allow the deck to remain, the staff recommends that such approval be conditioned on one, that the removing the portions of the deck in A, C, and E that encroach in that 5-foot disturbance zone. And that's just the yellow pieces. Probably just trimming the edge. I'm not sure how it's built, so I can't tell how hard that would be. And then 2, submitting a building permit application, including the building construction plans for review by the town zoning and county building department and pay all applicable fees. 3, complying with all the provisions of the Grand Lake Municipal Code that relate to the deck, including but not limited to 12.229A5, which is the shoreline. And 4, refraining from using the deck until construction under the permit has been completed and approved by the building inspector. And that's the county building inspector. They do all the structural. It would not be the town. And then number 5, complete the floodplain application by obtaining the encroachment analysis. It has to be from somebody, a professional that has a license, engineer or other, to demonstrate that no more than 1/2 foot rise in base flood elevation exists between existing and post-construction conditions of the floodplain application, and provide documentation on how the deck is anchored. It would also be suggested that a condition be added for the shoreline vegetation to remain at the current level to protect their investment. So right now there's a bunch of willows growing right next to the deck, and they should remain. And if they go away or start going away, they should replant to make sure that their shoreline stays. And those images of the willows are in figure 10 and figure 11, if you want to see that. As far as the exhibits, Exhibit 1 is on page 14. That is the letter that we sent them that basically says, could you please comply with our code? And just a quick letter. And Exhibit 2 on page 15 is a letter from their neighbors when we sent the notice. And I'll read that into the record. We are the owners of Unit 1 in Rapids Condominiums 220 Rapids Lane, located to the immediate south of the property, requesting an exception. We appreciate the opportunity to provide our input regarding the applicant's request. We were fortunate to have scheduled a stay in our unit shortly after receiving your notice. We viewed the new decks just from our landing outside of our Riverside exterior door, then walked the decks for an up-close inspection. To us, it's a vast improvement over the previous dirt surface. Shortly after emailing pictures of the new decks to our fellow owners and passing on our observations, we received a copy of a letter to the Planning Commission signed by several owners voicing what seemed to be legitimate concerns. We spoke to the owners of the Rapids as well as Kimberly White to better understand whether our fellow owner concerns were ones we should share. We learned from these conversations satisfied us that the city and its professional planning and building staff will ensure that the construction meets building codes and be safe for diners. There will be no possibility of decks floating downstream onto our property. The decks will not be allowed to damage the shoreline. And finally, Ms. White indicated that this would not be the first exception granted, so it would not be setting a precedent. And they signed their names, the gullies. With those concerns satisfied, we fully support the allowance of an exception. Please feel free to contact us at this phone number. Sorry. Exhibit 3. This was sent, I believe, from neighbors as well. Thank you for your notice regarding a deck project completed at 210 Rapids Lane. While we do not wish any harm or inconvenience to the owners of this property, we are writing to express our strong concern and opposition to this project. This letter is signed by 3 separate owners whose names and addresses are identified at the end of the letter. Our objections to this deck project are for the following reasons. First, this project violates current laws for stream and lake setbacks, which we believe are helpful regulations both for public safety and not disturbing water shorelines. We hold there is not good reason to give an exception to these laws in the case of this project. See below. Second, this deck was built without a permit. This is a significant oversight that gives us no confidence it was built properly or is certified to be safe. Next, we have concerns that a floating deck, which we assume means that it is not attached to a structure or to the ground, located directly on the shoreline and in some spots over the river, is unsafe. This concerns us both for those who will use the deck and concerns us as neighbors downstream from the deck. We all know river water levels are not consistent. Example, after the recent fires, we use sandbags to protect our property from rising river levels. And this is where current ordinances are important to maintain public safety. In addition, both of our properties and 210 Rapids Lane, people come onto our property to view and enjoy the riverfront that are not residents or customers at the restaurant. The floating deck creates a liability for unsupervised people. Finally, and most importantly, if this project is approved by the Planning Commission, it will invite a slippery slope scenario where other property owners with waterfront access, including us owners, will be emboldened to follow suit and cite this exception as precedent. We strongly encourage you to protect our current ordinances and not allow this project to be maintained. For the owners of 210 Rapids Lane, While I'm sure it would be a disappointment, I believe moving the deck back towards the building and out of the non-disturbance and shoreline protection zones would still provide excellent seating for their guests. Thank you for considering our comments. If we can provide any additional input, please do not hesitate to contact us. Signed. Exhibit 4 is the stream and lake setback information, the application that the applicant submitted. So to show that it's complete, minus the encroachment analysis that we didn't know about until we review the application. The request, attachment A. Okay, now this is all of their application. And in the application, they have listed their reasons for their hardship and why they believe they comply with A through E. That is on page 19. So this is a request on page 19, and have you had a chance to read it or? Yes, okay. Then I don't need to read this under attachment B, request for variance. That is the practical difficulties or unnecessary hardship. That is on page 21. And they have attached a letter that was sent to them on page 24. And that was not received by the town as a notice, so I'm not going to read it in, but you can read it and it's in our minutes and our packets. And they have attached the floodplain permit, and the last page is the resolution draft. It's just a draft, and if you find one of the items A through E, we will we'll mark through whichever ones you don't find on page 29, and we will reprint this at that point, because you only have to find one of them, so not all of them will stay on that resolution, unless you find all of them, which is fine too. I think that is all. I think that covers it for this. Scott, did you have?
I think Kim has covered everything. I think the main thing to keep in mind is that the only issue before you tonight is really the 30-foot setback variance request. The 5-foot non-disturbance, you can't grant a variance for. That has to be complied with. So you're just looking at the 30 feet, and probably the draft resolution that Kim provided on page 28 is a good reference point, because it sets forth the 5 criteria that you can look at. And as she mentioned, you only have to find one or more of those in order to grant the variance. And I would encourage you to indicate which of those you find as based on the evidence that's presented. And then the other part of your task is the conditions, which appear on page 30. Those are the conditions that Kim just mentioned that are recommended by staff. And you guys should decide which of those conditions you think should apply to this variance if it's granted, and which ones you do not think should apply. And then in terms of the applicant's view of the matter, probably the best summary of that is Exhibit B of their application, which is on page 21. And there, their attorney goes through and indicates how they feel they have satisfied each of the 5 possible reasons for granting a variance. But they'll also have a chance to present that to you tonight. So that's really the focus of tonight's discussion. The applicants asked if they could pursue the variance first to see if they get the variance, and if the variance is granted, then they'll follow up with the permit application. So the permit application is not in front of you tonight. It's just a matter of whether or not the 30-foot variance setback should be granted. And I'll be glad to answer any questions.
All right, thank you. Anyone have questions for staff? If not, we'll
Move over.
See if the applicant.
Applicant.
Well, we will. I just, if you have questions for
okay.
staff on the staff report that was just presented. If not, we'll move on and invite the applicant up. All right.
Good evening. Thank you for taking your time to hear this matter. And I know Mr. Ludwig would also like to speak. Really at issue here.
Name and address.
Oh, I'm sorry, Natasha O'Flaherty, Never Summer Law, here on behalf of the Ludwigs who own the Rapids. At issue is the 30-foot setback. The reality is this building was built in 1915. A big chunk of the building is within the 30-foot setback. I mean, as we'll explain later, really they would be prisoners of the building because the front side is the road. The setback ordinance came many years, decades after the building existed. And my client really built the deck, or what we call the platform. I think in the packet it's called a deck. He acquired the property in 2017. The idea was to protect the trees and the tree roots and to provide safety for the guests so that he can operate a commercial business and get it insured. The permit was very legitimately, he did inquire, and even the attorney and I, we're trying to figure out the 105 exception for a platform that doesn't require a permit if it's at grade. What does grade mean? That's not here before you today. But the crux of the problem is a building that's already in the 30-foot setback. I mean, when the neighbors say, well, they should do something within the setback, well, they couldn't. They're right up against the wall of their building. Their building's even in there. So where we are today, the gazebo on the top half, yes, that was that in the last 3 years, new things were built. In terms of the condition and the erosion, and before we go to the exceptions and really discuss the meat of this variance exception, yes, a permit was pulled in 2018 before my client acquired the property. I think, when we say that it's a floating deck, I would say the pictures that are in the board packet show that it's anchored and built around significant boulders and trees. The assertion that somehow my client is killed, these were pictures taken when the wall was built. This was all before my client. I'm happy to pass these through, but that tree was dead. These are pictures back from 2014. So at the time, if you look at the pictures that the town presented you, there were no rose bushes and willows. It was rather bare. Once the flood prevention measure, the wall was put, since then the water's not come over and the vegetation has grown. The idea of the platform was to protect the tree roots, protect the customers. And the whole idea of the setback makes sense to me. And we should take great caution in granting variances of, does it affect water quality? There's nothing happening on my client's property that's toxic. There's no oil and spills, machinery. If you look at the statute, that's really where they were going with the setback. So the shoreline reinforcement has allowed vegetation to happen. Those boulders are there. There is encroachment on the 5 foot, and my client sincerely apologizes for that, and he will address it. He has no problem cutting it off. I think I might ask the board as we go forward to permitting with the variance to allow boulders to be put to make sure that people don't fall off the edge of that. That work was all done with a permit. That, again, was before my client owned it. And the deck, I think there's been a lot of concern that the platform is floating. Again, if you look at the pictures, it is securely anchored around boulders and mature trees. There has been no disturbance of the soils. I appreciate that the town is willing to allow the de minimis intrusions. My client's happy to trim them back if a variance is granted. The encroachment analysis, if a permit and encroachment analysis is required, we have no issue taking care of that. And if I can really go through the individual, and I know you've had a chance to read them, but again, any one of the 5 would qualify for a variance on the setback So I mean, the first one is just that there's practical difficulties or unnecessary hardship that would result from strict enforcement. That's what I mentioned to you earlier. The building itself is within the 30 feet. It was here for decades and decades and decades before there was that setback requirement. It would cause extreme financial hardship for the Rapids. Like so many of the businesses here, 80% of their revenue does come from summer dining. Most of that summer dining is outside. And the exposed roots were really putting the trees at risk. It was also putting the diners at risk. And as a commercial enterprise, as many of you may know, any tripping and falling by a guest automatically leads to lawsuits. So that's really the first exception and basis on which you could grant the variance. The second one is that the literal interpretation of the provision would deprive the applicant of rights commonly enjoyed by other properties in the same districts under the town ordinance. Again, the Rapids building was built in 1915, long before the setback ordinance. If you enforce it now, you're really depriving both the owner and their guests the right of quiet enjoyment of the property. And it would really render the property without any meaningful outdoor space and the revenue that comes from that commercial enterprise. So I think it also meets that requirement. In terms of the third requirement, the special conditions and circumstances do not result from actions of the applicant. Again, the applicant didn't build the lodge, the restaurant site for the lot. He does have a commercial license with you. He pays his taxes. He's a great revenue source for your town. Again, as built, the building itself encroaches on the later adopted a 30-foot setback. Enforcing the setback renders the property without meaningful outdoor space. Because again, in the front, you have the road, and then you have the setbacks from the adjacent building. So the only space where the commercial business can operate is towards the river. Brings you to the fourth of the 5 options of granting the variance request will not confer an applicant any special privileges that are denied to land structures, buildings in the same district. Yes, no special privileges are being conferred that's denied to anyone. The patio at issue is core to the business and access to the waterfront. Docks, boathouses, commercial marinas, businesses in the same district all afford that same benefit. This applicant shouldn't have an unfair disadvantage and be deprived from his waterfront enjoyment. He is taxed as a waterfront property, so he should be able to use it as a waterfront property. And then lastly, on top of the first 4 that I do think apply, the 5th option on the basis on which you can grant a variance is that it doesn't pose detriment to the public good and does not substantially impair the intent and purposes of the municipal code cited here of 12-229. And again, the stated purpose of the whole setback is to preserve the water quality in Grand Lake. I respect that, as does my client. The ordinance goes on to address buildings, parking, snow storage. Obviously, snow storage has a lot of debris and oil in it. I totally get that. I think this is a very different character of use, and it is designed to appreciate and enjoy the water without harming it in any way. We're not posing risk of contaminants. And I think the protection of the mature trees and watching all the vegetation that if you look at the picture submitted by the town, pre the flood prevention wall going up, there was no vegetation. That property would have continued to erode. I think it would have over time put the building at risk. So I think the platform serves its purposes very, very well. And certainly if a building permit is required and it's not considered an exempt platform at grade under 105.2, my client has no problem requesting that permit if a variance is granted. And same thing with the environmental regulation to make sure that we have no pinch points from the flood. The terrain on this property, as some of you may know, is flat. It is just running parallel to the river, between the river and the structure. So those were the key points I wanted to address. I am more than happy to address any of your questions that you may have.
All right, thank you.
So we would appreciate the approval of the variance on any one or all 5 of the reasons we've cited. Thank you. And I think Mr. Ludwig would like to speak with you briefly.
You can just give us your name and address for the record.
Max Ludwig, owner of the Rapids, home address is 114 County Road 4624 Grand Lake. Good evening, thanks for being here. I appreciate the service everyone is giving. It's rough to give up your Wednesday night, every other Wednesday night. And I appreciate it, especially when you sometimes make decisions that make some people happy and some people mad. I get it, and I appreciate your position. A certain amount of time ago, I decided the Rapids needed to improve the safety on our patio. And like nearly everyone else on the planet, I Googled whether I needed a building permit or not. What I came up with was that a platform less than 30 inches high and not attached to the ground or a structure, no permit is needed. So I followed those guidelines and I built it. And if I don't say so myself, I think it turned out pretty good. For those of you who have seen it in person, thank you for your business. For those of you who haven't, Ms. White and I have provided you some pictures and you can be the judge. The next thing I know, we got a visit from Mr. John Crone, the town manager, saying there's been some complaints about our deck. And we agreed to meet and try to come up with a solution or figure out what the problem was. That meeting was canceled a day or so before we were supposed to have the meeting. And the next thing I know, I got a certified letter stating the problem, and here we are. So I wanted originally to solve this problem the right way. And then we got the certified letter, and now we have to go through the whole process. I thought I was doing it the right way. I want to do it the right way and solve this in a way with the least amount of brain damage and financial problems for not only me, but for the town as well. So the hoops that we have to jump through are fine as long as it's in a fair manner. And I'd be happy to take any questions if you have any for me as well. That's all I have to say.
All right, thank you.
Just a couple of things to clarify. Your attorney referenced a 2018 permit. Did you hear that?
I'm assuming that permit is for the wall.
Okay.
The pictures that Ms. White included in your packet were taken by the town planner at that time.
Okay.
And she oversaw the building of that wall.
Right. And I don't think that's an issue. I just didn't know what permit, we were talking about. And
I think that's the permit.
okay. Okay. And I think she indicated that was done by your predecessor. That wasn't done by you.
Previous owner.
Okay.
The wall was built by the previous owner,
And who were the previous owners?
Tom Ludwig.
Okay. All right. Thank you.
Any other
I thought
questions?
I had the reinforcement of the shoreline. I thought that was in 2011. And I believe you said that did get a permit and had town approval. Okay. Is that what you were just talking about?
Well, there was reference to a 2018 permit too, and I just wasn't sure what that
Oh,
was.
and I don't know what that one was.
Yeah, it sounds like it was, it was a permitted activity, so I don't think it's an issue.
And that's one other thing I will say. The previous owner did not serve lunch. So he didn't need necessarily the level ground that we need to serve lunch and to be safe. The people that he had outside were just mingling and possibly drinking, but he didn't really serve food outside. And that's a big part of our business. We've kind of changed it since we've taken over. So it became a problem. People on the dirt, uneven, tree roots. The deck served two purposes. One, to make it safer for our patrons, and two, to make it safer for the trees and the dirt. There's much less pounding and wear on the shoreline now because it's protected by the deck.
Just out of curiosity, the concrete walk and stuff, is that where people used to be served prior to?
Correct. And if you notice, I'm not sure if you have it in some of your pictures, but I do have some other pictures. There's pictures of the shoreline before the deck, and you can see chairs that we put out there for people to sit on. And they're leaning downstream. People would fall over sometimes on those chairs. So it became fairly unsafe.
And previously, when the grass was green, as it was shown in one of the photos, was that watered or?
It was watered on a regular basis. And again, it wasn't trampled upon nearly as much because they didn't serve food outside.
Okay.
There was nowhere near as much traffic. In addition to that, as we probably all know from living up here, that ground is all under those pine trees, and they drop those needles and it becomes very acidic, and it's nearly impossible to maintain grass under, not only in the shade, but in those pine needle in that acidic environment. So everything there that's growing now on the wall is fairly natural. I didn't remove any rose bushes. There's a lot of natural or wild rose bushes there and other natural foliage. I didn't remove anything. I didn't even level the ground. I didn't move any dirt, nothing. And we did have one positive letter that didn't get read. We'd like to.
And maybe Mr. Shockey, in response to your question, I think the green lawn is the fantasy we all would love to water and have. Prior to the wall being built, because of the heavy erosion from the river, there was no grass. There were no willows. There were no rose bushes. So after the wall was put up to make it aesthetic, they attempted to put grass. But prior to the wall, the natural, and it's very similar if you hike up the river, when you look at the shoreline or the river banks, you don't typically see green grass. So just to clarify, there was no green grass pre-wall.
Right.
As we all know, grass is not natural.
Yeah. And I think consistent, and I did ask Max, and there was one letter in your packet that we submitted with our application from Bob and Adele that they said, thank you for the improvements you've made to the Rapids outdoor dining experience. There wasn't much of anything to improve with the meals and service guests regularly receive, but the outside dining in the past on even ground was somewhat difficult to maneuver. As desirable as most guests found outside dining at the Rapids was, the new decks added the last 2 years ensured that not only unparalleled Grand Lake dining experience, but they added greatly to the safety of your guests. Sadly, during a walk along another waterway trail in Grand Lake this summer, a family member fell on uneven ground along a relatively flat trail and suffered a concussion after a face plant on the ground. Thank you for improving the safety measures at your outside dining tables. That was very thoughtful and much appreciated. Again, doesn't really speak to the 5 reasons that I think are supported, not just one, but all 5 for the grant of the variance. Again, it was done with great intentions, and we accept the conditions that if a permit is required and the analysis is required, we will certainly do those steps. So thank you. You have more pictures you wanted to show, Max?
All right, is there other questions?
Scott, when you're talking about the wall, you're talking
Can you
about
push
the
your-
boulder.
Thought I was on the boulder wall on the river.
Yeah.
That's what there's, okay. So did the town approve that or was that?
Yes, that was done with a permit.
Okay, so I think kind of behind your question is the variance question didn't come up then.
No, they mentioned a permit and I wasn't sure what permit they were talking about. And they thought it was maybe the permit that they pulled when they did the wall. So, yeah, no, the variance just applies to anything that's within the 30-foot setback area. And the wording of your town code is, any improvements. So that's really the only issue is, whether the wall's there or not, is it within is the deck within 30 feet of the water? And it is. And if so, does it meet one of those 5 criteria so that you could grant a variance?
Right, I guess what I'm asking is if he hadn't done the deck, this issue may never have surfaced.
Correct. Yeah, the only setback violation is the deck. not the wall.
Not
So-
the concrete patio.
Yeah, the concrete patio preceded as near as we can tell, the setback regulations, so it's grandfathered in, it's a legal non-conforming use.
And the date
about-
on that regulation possibly?
I don't know, I'm guessing those were adopted back in the seventies, but the building was built in 1915, and we assume for the benefit of the applicant that the gazebo and the concrete part of the deck have been there long enough that they were entitled to be legal non-conforming uses.
And then what about the,
We don't know that for sure, but that's what we're assuming for the.
Yeah,
benefit.
we didn't have anything that indicated to the contrary.
and then what about the encroachment of, say, the dining and the tables and things like that that have transpired since change of ownership? Is that, even if the deck wasn't there and they were encroaching upon the 30-foot setback, is that permitted with those, like to serve and to run their business in that
Yeah.
setback?
I don't know that staff has looked at that. I think that the historical use, it sounds like from the applicant, is people would go out there and sort of mingle.
Mhm.
And I don't know that there's anything that in our regulations that prevents them from doing that in the setback. It's when you start making improvements within the setback area that you run into the language of the code that says you can't do improvements in that 30-foot area.
And just a table and chairs is not really.
Yeah, generally an improvement is something that is relatively permanent in nature. And so I didn't anyway view the tables and chairs by themselves as improvements. I think that's a fairly common use within the 30 feet of the waterways throughout the town.
Okay.
There is a commercial public area, and there was some mention in here about does it have to be ADA compliant?
So the ADA compliance is not anything that is in front of the planning commission tonight. It's just a matter of whether they can put a deck there. And then when they come for permit,
That's in the.
then they
permit.
would have to look at whether that decking has to be ADA compliant, and that would be addressed by the building department.
Yeah, right, that would be part of the building department.
Yeah. And if I've got that wrong, I'm sure.
Gotcha.
Kim will pick me.
That's correct. And the county would be confirming that.
Yeah, and I suppose, and I'm not sure how it is, actually getting out of the building onto the concrete pad. That also may require something
Yeah.
too, but that's, okay. I was unclear about this FEMA requirement on the 1-foot rise.
So that's part of the floodplain regulations.
Yeah.
And depending on how close you are to the river determines how much of a no rise area. If you are sufficiently close to the river, then you have to get essentially an engineering analysis that says the improvements you're building will not cause any rise in the river. If you move further
Oh,
away,
I see.
then,
Okay, I got you.
yeah,
Right,
where
so
they are,
right.
they're in an area that they can't have more than a half
Okay.
foot rise.
So that's, has nothing,
And,
okay.
and that will be part of the floodplain application that if the variance is granted, they've agreed those.
Okay, okay.
And then I guess what happens if they don't meet those requirements, and at that point, they're having to redesign the deck, is that?
Yeah, I assume that will be part of the building permit application.
Okay.
In our,
This was all new to me as well. That's a world of law I don't live in normally, but it makes sense. If I build, let's say, a shed in front of the rapids and it's, let's say, 10 foot by 20 foot and the water, and candidly, if this deck that's anchored in on the boulders and trees gets ripped out, we have a bigger problem in Grand Lake. If I understand this correctly, and Mr. Krob, you can. So I build this shed, tool shed. And now when the water comes up, it has to go around it. So it is raising the water table up. And certainly, assuming the variance is granted, we will take all the necessary steps that are required. But I do believe from what I've been reading that that's the idea of, is there something you're building that is then going to cause the water level to rise? If I put a 10 foot by 20 garden shed out there, the water comes up to get around the building, it's going to push the water levels up.
Yeah, that's the purpose of the no rise requirement.
Yeah.
Mhm.
The other part of the floodplain requirements is anchorage, because they don't want it to be something that's gonna come loose in a flood and go
Right.
downstream.
So if that answers your question, I had the same thing when I first read it. That was all new to me. I had to dig in and find some examples. Um, and again, that would be part of the application. I would assume, since we really are just almost at grade. One of the things I suggested when we come to building permit time, is it easier just to put gravel to protect the tree roots? And then the platform is at grade. Yes, right now it is slightly up because soil over the decades had eroded. So the tree roots that were tripping customers that really prompted this are higher than this ground of a few inches, depending on where we were.
Thank you.
There is,
Sorry, I think we're getting a little ahead of ourselves with questions, especially of staff and things. We should probably finish the public hearing and then we can close that. So, are there members of the public that wanted to speak? If you could, give your name and address for the record and limit the comments to 3 minutes.
Will O'Donnell, and my home address is 185 County Road 4693. I think that it goes without saying that the deck is a wonderful enhancement to the shoreline. It's a wonderful enhancement to the enjoyment of the shoreline. It's a wonderful enhancement to the safety of people who are enjoying the riverfront. And as far as the water quality setback, or the 5-foot setback for that matter, there are all kinds of structures that are waterfront structures that are built within the 5-foot setback. There are docks and gangways that go out to docks. There are boathouses, there are stairways to boathouses, all within the 5-foot setback. And so I don't really see that this is a lot different than, say, the town's dock and gangway to their dock. Then a couple of other considerations. I believe that the flood zone determination was done long before the shoreline was enhanced with protection. It raised the shoreline, and I think the flood zone probably changed because of that. Last year, I think, was our biggest snow year that we've had in decades. And it didn't threaten the shoreline along the rapids frontage. I just don't think that it's a likely problem. And then finally, I think that this is a structure that is more analogous to landscaping. If the Rapids had built a flagstone patio, they wouldn't have required a building permit or scrutiny of what was in the setback or not. So I think this is, a typical waterfront structure that is more analogous to landscaping than it is to building. And that's all I have. Thank you.
All right, thank you. Anyone else?
Donna Reddy, 1133 Grand Avenue. And I'm talking about my property, which is just a couple hundred feet upstream, 217 North Inlet Drive. So we love sitting outside by the river. And I love watching the people at the rapids sit out by the river and watching them enjoy it and enjoying it myself. And I think I speak for all of you and for everybody who's ever had lunch outside there, that it's wonderful. And let's just make this really easy and move.
Thank you. All right, if there's no other public comments, we'll go ahead and close the public hearing. We'll turn it over to the commission for discussion and decision. So I had one question for Kim, and one of your conditions, you stated that there's certain areas where the vegetation should be maybe enhanced and more dense. How is that a condition, I guess, that gets enforced? Is it that they have to plant certain things as part of the overall approval? I mean, obviously.
That it stays vegetated, so their shoreline stays intact. So if
Mhm.
there was any disruption that they noticed, I don't plan on going over there and citing them for anything, but.
Right,
um,
okay.
I have an issue with the suggestion about willows. I think we should not specify that. We should say any native aquatic species because willows can be a nuisance. And if you were to plant them all along that riverfront, that might be a problem for them. And so I think we should leave it up to them to choose what type of appropriate plant to plant.
Was it specified for willows?
Willows was mentioned in here because there are existing willows to plant willows if those should die. And I think we should just leave it up to them, say a native aquatic species that's appropriate to the area is good enough and let them decide.
Yeah, and it looks like the condition just says riparian vegetation. Doesn't specify certain type.
On page 11, the bushes that they have over there is, enhances the beauty of it and it doesn't impede the view shed of the river. So it's just those low bushes, those are fine. I think the applicant would be interested in maintaining that aesthetic value to it. In our municipal code, we don't have any kind of a definition of a floating deck. And we do have like a walkway and a stairway. And as the proponent's attorney
Hey,
mentioned,
John, can you talk into your mic so we can make sure Greg can hear?
as the proponent's attorney mentioned, referred to the deck as a structure, and it is indeed a structure. So that's, yeah, unless there's, yeah, anyhow, a floating deck again is not in our municipal code, and I believe it more falls into the category of structure. And also there was a comment about well, if it were just flagstone out there, that wouldn't be a problem. I think flagstone is also, a structure. It can be considered as. So, but anyhow, that's kind of a subtle point that could be argued against.
Yeah, I think,
I think having a cocktail or having lunch on that deck is one of the treasures of this town. And I think it would be a hardship to deprive them of that. I agree with that.
So Scott, we asked, if the structure wasn't built, would we be sitting here? And the answer was no. If it was flagstone or a concrete, slab, would we be in the same scenario?
We talked to the building official Peter Rempel about that. And he said that because what your code talks about is other improvements. And he treated that as anything above grade, because it's not just what's in your code, but your code incorporates the building code. The building code characterizes it as platforms. And so platforms are things that do fall within the permit requirement. He said that if it was, for example, if it was just, they poured a slab that was at grade, that it wouldn't trigger it. But since it was a platform, that it does trigger. Anything above grade, he said, would trigger. So that was.
Triggers a building permit is what Peter said. He doesn't do the zoning for the town. So it would have triggered a shoreline variance because it's any activity in the 30-foot setback. But it's not, wouldn't need a building permit to put the flagstone down.
Yeah, what triggers it under your code is an improvement to the site. Language that
To the setback specifically.
Yeah, I mean, obviously, I do agree that the deck is an improvement over the compacted loose soil that was there. I have a hard time with the argument that they don't have an enjoyment of the outdoors because the structure was built before the regulations. The structure is fine, right? The concrete walkway is acceptable because that was built before the regulations. So all of that already provided the outdoor enjoyment for the enjoyment of the property, correct?
Yes.
Okay, I just wanted to clarify that it's not,
Yeah, we aren't questioning the 30-foot building being in the setback or
Right.
trying
So
to
they-
restrict any use of any decking or the walkway that's existing.
right, okay.
The concrete is what I'm trying to say.
I just wanted to clarify if that was the case.
And one question on page 4 has the schematic of the deck and the layout. There's a black line that goes through the platform deck. You know what that indicates? Starting at the gazebo.
You know, I thought that was their property.
Is that a property
I
line?
thought that was a property line.
That's what I thought it was.
That's
as
what I
well.
think it is.
So I assume these lots are combined then? Is that? No.
So whatever's going through the deck there, the black line.
Yeah, they
is
say
that-
they own the river. They say that they have ownership of the to the center of the river.
Property line.
Yeah.
It's all one big lot?
But then that other line in the middle, do you see what he's pointing at? Yeah,
Yeah.
so it looks like it's two properties.
Arrows to it or anything to.
It is, as far as I know, it's one lot.
But what is that line that goes through the deck there? The black line.
I'm not arguing that's 2 lots. I'm just curious, I know some parcels go out to the middle
Oh.
of the river, 5 feet out in the
Yeah.
water. I'm just.
Oh.
Yeah, I mean, the survey shows it's like there's a parcel B and then there's
Oh,
a
right,
lot
okay.
18 block 1.
Oh, right.
Yeah,
Oh,
if
yeah.
you go to the survey
Okay, I
on
got you.
page 23, it kind of shows it a little bit
Yeah.
better.
Okay. Got it.
Other questions, comments, thoughts from the commission?
We are just looking at improvements within the 30-foot setback today.
Correct. If the deck as constructed should be permitted within the 30-foot setback. And there are 5 conditions or 5 findings that we should probably review and determine if we agree with those findings. And then there are conditions as well that need to be reviewed and determined if those should be applicable. So the first finding is that the planning commission considered each of the factors required by section 12-229 2B. Can you pull up those so we can
Yeah,
review
what
this?
page is that?
On page 29?
Yeah.
Well, 29 is a resolution, but the
Well, it
section of code
identifies
that
it.
you're referencing,
So the conditions that are in that section are the numbers 1 through 5 at the bottom of page 29 and. here we
Yeah.
go to
Okay.
page 30.
okay, so then,
There.
Oh, yeah, or they're at the last page, yeah.
okay.
Which one do you want me to go to?
And I would
29.
say that,
Start
certainly,
there, so. That reason by exceptional size, shape, or topography of the lot or other exceptional situation or condition of the building or land, practical difficulty or unnecessary hardship would result to the owners of said property from a strict enforcement of these regulations.
I would agree that that fulfills it.
See, and I would have to disagree just because they already have existing encroachments that were permitted long before the shoreline. I mean, it's not like these shoreline regulations are new. And that operation has existed since, 1915 when it was built.
Yeah, newer than the building.
Right, so. Not saying good or bad, I'm just arguing, I guess that, I don't know if it fits that qualification, but
Well, in number 4, in granting this variance request, and it does not confer any special privilege for other people. So it satisfies that. And also, 5 is questionable because it isn't different from the regulations. 1 and 4, in my opinion, I think it's.
I guess, question for you, Scott, if the planning commission did move forward with granting this, is there language that can be added that specifies maybe that this is appropriate because it is a commercial operation and not necessarily just a private residence? Because I guess that's one of my concerns, is that we grant this, we could start seeing other applications for a deck along along the north inlet. Is that possible that you could, in the resolution, you could put that distinction in there?
Yeah, I think that you could put, based on the finding of the commission that this is a commercial operation, it deems the following criteria to be satisfied.
Okay.
And the historical use of it. I mean, you don't go too many spots along the Tonahutu and see people mingling
Mhm.
on the shoreline, really. So kind of
Right.
was they set the stage that this is a spot for that.
True, yeah. Yeah, I just would rather have those kind of provisions put into the resolution, just so it's clear if the commission moves forward with it, this is why we're doing it. It's
Yeah.
not-
Our job is to make sure the commission, that the resolution reflects your finding. If that's one of your findings, we consider that.
Okay. Thoughts from other commissioners on that?
Well, I think part of my concern is in relation to at least one of the letters that we received about the effects of a floating deck on downstream properties. I know that in the history of this property, under the condos right next door to the restaurant itself, when they were first constructed, they had many problems with floodwaters getting into the basement areas, the garage areas underneath the condos. And having experienced at one time, not too long ago, when we did have severe flood indications, part of a problem that was created was that things did float down that river and congregated under the bridge on Grand Avenue. And it was an all-night operation to remove trees and boulders and other debris that had gone down the river. So I do think there is some concern about that. And I think the other owners, pardon me, the other owners have shown that concern. So I'm not sure that particular item is really solving the problem without having the building permits to know whether this is going to stay in place. If it's a floating deck, is it going to float down and congregate under the bridge and flood that whole area?
Right, and I think that's where staff has tried to add in those conditions that a building permit be required, and whatever anchoring needs to be done has to be done, as well as the requirement of the FEMA floodplain, so that if it in fact does pose a flood risk to other properties, then they have to do something about that, so.
Scotty, when you started, were you telling us to split our decision to agree or not agree to the 30-foot first and then come back to the conditions?
No, I think that you have to do it all together. I think first you have to look at those five possible reasons for granting the variance. But you also have to do it in terms of you're granting the variance as long as these conditions are imposed.
Okay.
So it's not just say, yeah, you got the variance, now let's talk about conditions. I think you're granting the condition and saying, yeah, you're okay with it as long as whichever of the conditions you think should be imposed are
Right,
part of it.
okay.
In those findings that are up there, we can't change the language on those, right? It's,
Right.
those are from the code.
Those are out of the code. Those are, the, 12-2-29 subpart 2B through E. Or A through E. Wrong section. Section.
And we only have to
12-5.
find one of those?
What's that?
We only have to find one?
You
At
only
least
have to
one?
Find one. This is a little different from your typical variance analysis. Usually to find a grant of variance,
Mhm.
you have to find that all of the criteria are satisfied.
Right.
So your code reflects a gentler standard for this 30-foot setback area and says you only have to find one or more of those to exist in order to grant this variance.
That's
Okay.
only specific to the stream and lake setback,
Correct.
but the other ones are, have
Yeah.
to have all.
Right, your typical setbacks like, you know, your side yard setbacks, things like that, you would have a much stricter standard.
Yeah, cause I mean, I find two in. Are those the section? No.
Yes.
Okay.
So you're supposed to consider that?
Okay. Cause yeah, I have a hard time with.
Oh, yeah. Yeah, it's A through E up there. And it's
I
one
guess,
through
yeah, I have a
five in the
hard time
resolution.
with B and C being, or D even being items that we could say, you know, well, for instance, B, would it derive the applicant of rights commonly enjoyed by other properties? It wouldn't, because we don't commonly allow for decks to encroach within the 30-foot setback. C is that it didn't result from the actions of the applicant, and obviously it did, that's why we're here. And then D, we would be granting special privilege, if we did grant it, but, I mean, I could get behind possibly A and E. Because I do agree that the deck probably does provide a better protection to the river than just having soil there, loose soil that people are trampling on. But those are just my thoughts. Love to hear from the rest of the commission.
Well, I agree. I think that just based on reason A, the topography of the lot, I think this is an improvement, you know, to keep the soil out of the river. A deck is a very good choice, and you can't keep your guests from going up to the edge of the river and they inadvertently might kick some dirt in. I think the not only protecting the roots of the trees is a great idea, but also just the soil eroding from people walking on it is going to happen. And I think a wood structure that they can stand on is going to prevent that.
And number E is kind of a backwards one. I would say that the applicant was concerned about the liability without this of somebody tripping and falling on a rock.
The applicant could close the area down due to safety reasons, obviously, but that would be a downfall of the business for himself as well as tax revenue for the town, so.
All right, well, I think we've all said what we've thought, so do we want to move forward with the motion?
Which one's A through E? My opinion, A and E
Yeah,
satisfies.
that's the only two that I could get behind. The other three are, I don't know how you would justify those, so.
You only need one.
But if you find two, I would encourage you to.
Yeah, I was gonna say two is better. I mean.
Better than.
More defensible.
And I think if,
Agree on one?
On A and B. Sorry,
Uh,
A and E,
One of them anyhow.
A and B.
I think it was A and E.
A and E.
Echo.
Oh, and B.
Yeah.
E and E is E.
First one and the last one.
First and last.
First one and the last.
Thank you. Okay.
Well, if we've had enough discussion, I'd entertain a motion,
the only thing I'd suggest is that if you're considering A and E, that you also look at the conditions and see if A and E fit, that you're okay with the conditions, which are listed as A through F on page 30. Proposed by staff. And then if you're okay with A and E and the conditions, then you could just approve the resolution with those modifications.
And I think Natasha said the applicant agreed to all of the conditions. Did you not?
I said, I would absolutely have no issue that if a building permit and the wetlands analysis was required, absolutely. I have a concern about the vegetation because there was nothing prior to the wall. The wall was built. This is now protecting the trees and vegetation. I hate to impose what nature's already giving, and I think as Commissioner Bishop put, well, which plants, some naturally go, just like that one tree back in 14 just died. It was taken down long before my client owned the property. So absolutely on conditions, if a building permit's required, of course. C, I don't really agree with because the vegetation did come back naturally. I don't think this is anything within the town code. We're not requiring it of adjacent properties. I absolutely agree with the observation that yes, what Mr. Murray said, if it looks better, it's good for the guests. I think Mr. Ludwig is very happy that the rose bushes have come in, but to require landscaping, there's really nothing in your code that requires that.
Yeah, but it's something that the town can require because you're
It
asking
could.
for a variance from the code.
Correct.
Okay.
And I agree, keeping the trees healthy and having vegetation is another piece of erosion control and flood control.
Correct.
But the ones I was agreeing to, Greg, were definitely the compliance with any building permit requirements, that it complies with the code, that we're not going to use it until these requirements are being met. So I guess my only one that I really have issue are the plantings. And it's somewhat moot. They have thrived and went from having absolutely nothing pre-wall to now a fairly lush backyard. But just requiring it, I think Ms. Bishop brought up a great point of, well, how do you parse? Well, how many just naturally die off in a season or due to age? Do you?
Yeah, but I guess I look at it more as I want to make sure it maintains, not just gets cut down because now the view's being affected and things like that.
Oh,
So-
absolutely. That's a fair observation. That one concerns me. I guess I would defer to Mr. Ludwig on that one. But the others, we have no issue with. If they are required, we will certainly comply.
Okay. If you'd like to address the commission and then we'll turn it over to the commission for decisions.
Are we just discussing the matter of vegetation?
Yes.
Uh,
Maintaining of the
like-
vegetation.
Like Natasha said, everything that's grown in there since the wall was built up is basically natural.
True.
I haven't touched it. I haven't watered it, haven't done anything to it. So, which I think is a good thing because, now it's conditioned to live there on its own,
Right.
as opposed to grass, which has to be watered regularly.
And I think that's more the concern that staff had brought up, and I don't want to speak for you, Kim, so let me know, but it's that there is some sort of a level that gets maintained, that you're not removing it now because again, it's.
I think.
But what do we do in a drought year? Let's say we have 3 years of drought. Restaurant margins are skinny. Do we force someone to replant if we have 3 years of drought and the river goes down dramatically where these plants can't thrive? Then it would require watering and the expense of buying plants, and someone who goes to Lunsford and buys plants, they are sinfully expensive. Everything that grew here was natural. I think the one thing we've learned, and especially your town has learned, that we have aerification and wildfires are real and we're seeing much drier years. What is lush now may not be lush 5 years from now. I worked tirelessly with Representative Amable to get a lot of our insurance reform done, but we did so with the reality that the climate is changing and that we have significant aerification. So that's kind of where on that requirement, pulled back a bit. I mean, would we reasonably try and maintain it? Sure, but if the water levels fall down and he's going to Lunsford to buy plants and having to water plants, especially on a restaurant with single digit margins, that's typical in the industry, that's just a big burden.
Yeah,
Thank you.
Mr. Chair, you know, as a possible resolution, this is not a negotiation. I mean, it's not
Right.
like you have to reach an agreement with the applicant. This is a matter of what conditions this body thinks are appropriate. But what if we just inserted the word natural? So it said the applicant maintain or increase the natural riparian vegetation.
Okay.
Just a thought.
Okay, thank you. Did you have anything else or?
Just that, as he said, it's natural. I haven't really planted or even encouraged any of the vegetation there. It's just come up on its own.
Okay,
And I don't have any plans on taking it out.
right,
I think it adds to the aesthetic.
thank you.
Do you
And I
have,
think-
a-
Oh, did you have a question for the applicant?
is there, do you have a concern with regards to, the last item, that E over there about not using it until it's, fully complied with and certified by the town manager? I don't know, sometimes building permits with the county, sometimes it takes a lot longer period of time than what one would expect.
Well, most people don't want to eat outside right now.
Yeah, I know that.
And we have quite a bit of snow on it. I see what you're saying though, and I agree. It would be tough, if that took a long time and we get to June and we haven't gotten anything pushed through. But, hopefully we can get it done quicker than that.
The turnaround at the county is going really quick. It's like 1 to 2 weeks usually. And it's already built, so it would just be plans examination and confirming things.
Gonna be a-
I don't see why it would hold anything up for the summer season.
Right, it'd be the FEMA more than.
Okay.
Right.
And as your legal advisor, that's the one condition I would push for,
Mhm.
because if it's not permitted and approved, I would not want to see people out there again.
Right, okay. So thoughts on the vegetation?
Yeah, just insert natural.
Yeah,
riparian
I guess I would like
vegetation.
to, yeah, and also maybe insert language such as that it's not to be removed either. So it's to maintain the natural
Maintain or
vegetation,
Increase the natural.
yeah, but not,
Not
oh,
removed.
but not remove.
Well, what if, what if it's a sick plant? Don't you want to remove that? I mean.
Well, yeah, I mean, there's gonna be reasonable. There has to be. I mean, Kim's not gonna be out there every day documenting how much vegetation's there, but also if all of a sudden all the vegetation's ripped out, that's a little bit different. I'm not expecting that's gonna happen, but next owner or whatever comes in, they may choose something different, so. That's all I was thinking. And then I guess if somebody wants to make a motion, I would also like to have the commission consider, again, adding language in there that the reason this is being permitted is because it is a commercial operation as well, so that there's a difference between that and just a private residence that wants to do something similar.
Where would that be inserted?
I suggest that you insert that right at the beginning where it says, yeah, this is on page 29. There's some bold language there in the middle. Having considered the matters presented to it and the applicable standards, the planning commission makes the following findings. I would recommend you to reflect what the chair has indicated, right before item number 1, that you insert based on the commercial use of the property, and then start with 1. I guess it would be 1 and 5. Well, no, start with 1 and then let's see, maybe that's not the place for it. Let's try a different place. Having considered the matters presented to it and the applicable standards, and based on the fact that this is a commercial property, the planning commission makes the following finding.
Yeah.
Is it a commercial property? It's not CT, it's not.
Insert right. in
Well,
there.
as far as the commercial use.
Use, okay.
Yeah. All right, I'll entertain a motion.
So I'll move to adopt resolution 01-2024, recommending the approval of the variance to shoreline and surface water regulations with conditions as presented and amended. Do you want to throw in the amended?
I think as the legal counsel just noted,
Mhm.
and then are you only selecting the findings A and E? First and the last one?
We don't have to do that here, do we?
Yeah.
Yeah.
Do we?
Yeah.
Okay, so yes,
Okay, so striking B, C, and D.
right.
So in the, in the resolution, just to make it confusing, instead of A
One
through
and
E,
five.
we have 1 through 5.
One
So
and
my understanding of the motion
One through
is,
1 and 5.
yeah. And my understanding of the motion is that is the resolution as presented with the following amendments and revisions, that under the heading findings of the planning commission, the bold language will read, having considered the matters presented to it and the applicable standards, and considering the commercial use of the property, the planning commission makes the following findings. 1 and 2 stay the same. That the planning commission consider each of the factors required by section 12-2-29-2B. 2, the applicant established the following exceptions under 12-3-5A4A through E. And then the ones that would apply would be item number 1, that by reason of exceptional shape, size, or topography of lot, or other exceptional situation or condition of the building or land, practical difficulty or unnecessary hardship would result to the owners of the property from a strict enforcement of the rules. And number 5, that the granting of the variance does not impose a detriment to the public and does not substantially impair the intended purpose of the zoning plan and these regulations.
That's what I said.
Do we?
Said it in legal terms.
All right, we have a motion and a second. Is there any further discussion? Not all those in favor, say aye.
I,
Aye.
Those opposed? Motion passes. All right, there being no other items of business, unless there's items of discussion or future agenda items, we can entertain a motion to adjourn.
So move.
I'll second it.
All those in favor? Aye.
I.
Meeting is adjourned. 8:04.
And our next meeting's canceled, correct?
Meeting canceled.
6.
Summer's meetings canceled, is that
Mhm.
right? No.
Mhm. Yep. It's down. Always.
Hey, Max.
So our the council approval, they've recommended. Sneak behind.
So do we all get to go for lunch?
Hmm?
We all get to go for lunch?
If you pay for it.
Yeah. I knew you were gonna say that.
That's what I heard too.
No, don't you know you cannot accept anything?
Of course not.
But the town. So.
The question, I just had it broke down on Grand Avenue River.
Well, we used to have our Christmas parties over there.
And it's, you know, the big mansion right on Rapid
Down dinners.
Grand Avenue. And there's a structure out there.
Half as many employees back
Yeah.
then.
Well,
Of course, we didn't
yeah.
invite the whole town. We
What's that?
invited the
Yeah.
president of the
Like a
chamber,
little White House or something.
Yeah.
people that had volunteered.
Yeah, anyhow.
Now we get more. So.
Yeah.
You don't get your fancy gimmicks.
Yeah.
As fancy. They was, Girls did pretty good.
They've been doing pretty good.
Actually, Scott,